Hello, good morning or good afternoon, depending on where you are, and welcome to our seminar today on accessibility testing. We're going to have a legal update and a guide to minimizing liability and the risk of legal expense with Greg Williams, who's the Principal Strategy Consultant with DQ, which in turn is the leading vendor of accessibility testing services. Now, Greg's going to introduce himself more fully in a minute and talk to you about his agenda. But before I let Greg do that, just a couple of points of functionality and housekeeping. First of all, we're going to encourage questions. I hope that as Greg's presentation unfolds, plenty of those will occur to you. Don't hesitate to click on the live Q&A button, which is to the right of your screen. Write your questions and I'll be able to put them directly to Greg, either at the end or during the presentation if they're appropriate. If you need any help, then click on the help button, which is at the top of your screen toward the right. And please don't forget to visit DQ's exhibition booth. So you can see the visit exhibition area again to the right of your screen. Just click on that and there's plenty of content there, white papers and videos for you to download. And you can also, through the meeting hub, arrange to speak to DQ directly for more information about what they do and to arrange any follow-up that you'd like. Without further ado then, I'm going to introduce Greg Williams, who will tell you a little bit more about himself, about DQ, and his presentation. Greg.
All right, thank you, Matthew, very much for the introduction. I'll go ahead and share my screen and pull up my slide deck here so everyone can see it. And Matthew, if you could just verify that we're good to go there.
Yep, that looks great.
Awesome. Well, I guess good whatever part of your day it is to everyone. I love these worldwide broadcasts. They're a lot of fun. And I'm sure we've got a nice diverse audience out there to talk to. I appreciate the opportunity. I want to thank Matthew, QA Financial today to allow me this time to share with you some information, that I've discovered will help you and your organizations manage accessibility, manage some accessibility costs and some accessibility risk. As part of this presentation, I do want to say that I have a baseline assumption that most of the people listening understand the base theory of some of the legislation that's out there, as well as the Web Content Accessibility Guidelines and other things that enable accessibility or enable the assistive technology to work with our digital content. So there'll be some places where I might try to explain some acronyms or other things I throw out. I try to minimize that. But if you're a beginner, some of this may not resonate with you immediately, but I'm available, R. Gregory Williams, on LinkedIn. And certainly if you have any questions about some of the background things, you can shoot those to me. So a little introduction to myself. So again, Greg Williams, I'm the Vice President for DQ and Principal Strategy Consultant. What I do here is I bring the entire picture together in terms of accessibility as a practice or a capability for an organization. That includes the organizational change to initially implement, funding strategies, prioritization, tooling, automation, software development, lifecycle integration, policy, procedure, governance. I mean, you name it. Accessibility is really something that it is a journey for your organization. It is a change management exercise. So similar for those of you who remember when we went from mainframe to distributed systems and discovered the need for security, the need for things like performance, and then the need for things like privacy related to other government edicts that have come out there too. But our agenda for today, this first part, just a little introduction and review. I'm going to talk about the current legal landscape. Now, the legal landscape I'm sticking to is here in the United States because it is the most active in terms of litigation and litigation driving things. So I'm going to talk a lot about U.S. litigation, but I am going to touch on the worldwide scene and other legislation in different countries, in different areas or different sectors, and how that's going to kind of come together, I feel, in the next 3 years to allow us to have a good guide on how to not only meet the expectations and needs of the people with disabilities community, but also be able to do that in a way that limits your exposure or risk from complaints and lawsuits. I am also going to spend a brief moment on why all this matters. I'm going to go back to a study I did. I had fortunate to be able to speak with some Fortune 50 companies about litigation experiences to understand the true cost. And it's much more than most people think. It's a dirty little secret that a lot of people will say, I can settle this lawsuit for $15,000, when in fact, what you've just spent is $300,000 in costs and disruption because you've had to deal with the lawsuit. And then we're going to talk about strategies for risk mitigation. So what can I do to avoid the two major types of litigation and complaints we see? The first type is what I call kind of a drive-by lawsuit, a little predatory in nature. We've got some law firms that seem to want to profit off of the situation in the laws here in the U.S., and we'll talk about that. The second is, actual issues where you've got customers who, really want to use your products and services. They're unable to do it. They're very frustrated. They've tried, to work with you, probably, and they're looking for some type of assistance. So this is what I call a real lawsuit, where I've got a real customer who's simply trying to do something, and those people usually are a lot more accommodating in terms of, I really just want this fixed. So easier to work with, but still yet expensive, and may change your timeline, which causes your expense to go up. And then we'll have some time for Q&A at the end. So what are you going to walk away with? Again, I want you to understand the real story on legal costs. I want you to understand the evolution of demand letters and lawsuits affecting accessibility. I want to learn about a situation that illustrates actually 2 or 3 situations that illustrate in the legal system here in the United States where proactive investment in activity in accessibility mitigated risk and disruption, actually got some lawsuits dismissed. And then determine some steps you can take to mitigate that in your own organization. So the introduction for me, just really quick about DQ. I started working for DQ a few years ago. My background is I've worked in the Fortune 40 space in the United States for a few decades, retired early from a Fortune 40 company where I had founded and matured an accessibility program, and then looked for the best company out there to help me in this endeavor of digital equality. And DQ's our actual mission and goal is digital equality. So I joined DQ because I want to help other people do this. I've seen both the wrong and the right way to do it. I've got a team of people behind me who have also seen both the wrong and the right ways to do it. So it's a great place to be. But you probably know these things. We trusted by Google and Microsoft. 160. I have to put plus million Axe Core downloads. That's our rules library. I don't know where it's at now, but it's certainly far north of that. 250,000 weekly Chrome extension users. This commitment to no false positives is really what that means is DQ works on a business balanced interpretation of WCAG. We want you to do enough to provide a good experience for your users, people using assistive tech and people with disabilities, but you also don't want to go too far. It's a difference between having a system that's 99.9% available and a system that's 99.99999% available, which is exponentially more expensive to create. And then finally, we've got a very robust, very efficient suite that works all the way from when you type in your code from a linting situation to guiding you through repeated and consistent, manual testing. So who am I and why the heck am I here? So my friends in the industry call me GW. Matthew was asking, should I call you Greg or Gregory or R. Gregory or GW? DQ has a thing for hiring people named Greg. So I took on the moniker GW here. It's not the first time that's happened. So feel free to call me GW. So just a little bit about my pedigree here, about 10 years focused with accessibility, Fortune 40 program founder, and now currently the vice president and principal strategist for DQ in this area. So very exciting job and very exciting career. And I really am excited that I get to do this for, theoretically the rest of my career. As you can tell, I'm approaching the apex and down the other side of the mountain. So one thing I do want to say though, out of the many things that GW is, one of the things that GW is not is a lawyer. So I'm not a lawyer. This is not legal advice. DQ, in fact, does not provide legal advice. So this content is intended for your awareness. If you've got specific legal questions or situations, I urge you to consult your own legal counsel internal, or there's several firms around the world that specialize in this. So make sure you get a real lawyer for those types of decisions. But this is information you can help them with. And if you've got a lawyer that needs, more detail in terms of what's going on with accessibility, we very frequently work together with the general counsel and external counsels for companies who are having legal issues related to accessibility. So let's review. The first thing I want to talk about is the statutes that drive this. So the best thing, let's see, Vince Cerf, the inventor of Mother Internet, said at DQ had a big conference, virtual conference a couple of months ago, and Mr. Cerf was one of the keynote speakers, and he said we should be accessible just because it's the right thing to do, and I agree with him 100%. Now, that doesn't always sell at the boardroom. It doesn't always sell with people who don't clearly understand diversity and inclusion, or maybe they don't understand, the people with disabilities community. And certainly they're probably, if they're not for it, don't understand that it's actually not that hard to add this in and increase many of your business values, including your inclusivity, your market share, and other things. So beyond that, we have, luckily, the governments across the world have some statutes in place that drive some of this. So what requires accessibility? And I'm not going to tell you exactly what all these are. Again, this is something you can look up, and I've got a link at the bottom of this slide so that you can see a worldwide inclusive list of everything. But in the United States, the Americans with Disabilities Act, Title I, I'm sorry, that should be Title II and III. So this is state and local governments and public accommodations. And we got a couple of different section guidance. So 504, these are entities that receive federal funding. 508, these are things that the federal government in the United States purchases that have to be accessible. Non-discrimination, there's a bevy of state laws that have to do with non-discrimination. You'll find that New York and California, where there's a concentration of lawsuits, have some fairly strong laws, including a new one in California that we may talk a little bit about that's been used lately. The Air Carrier Act, people with disabilities should be able to fly anywhere I can fly. So people felt that particular need should be addressed specifically. We've also got one for Medicare, which is some healthcare in the United States. And then let's jump outside of the United States and talk about Accessibility for Ontarians with Disabilities Act. This is in the Ontario province of Canada. And Canada also has Accessibility Canada, which is going to be a nationwide rule that they're working on. And we've got the European Accessibility Act. So there is another 30 here that I haven't listed. I didn't want to spend a bunch of time reading the list to you, but you can go look. But you can probably bet that wherever you're at, there is something somewhere in your government support for people with disability that talks about accessibility, both from a physical and a digital perspective. And if there's not, you can definitely bet that in the next 2 or 3 years, there will be. So that's what requires accessibility. What drives accessibility? What guides it? How do we know what to do? Luckily, this entire list that I just shared, the requiring accessibility, is basing their guidance off of Web Content Accessibility Guidelines, so WCAG, you'll hear people call it. And so guiding accessibility, there are some major versions in play right now. We've got WCAG 2.0, we've got WCAG 2.1, we've got WCAG 2.2. So this is the 2 dot series. These are incremental improvements one over the other without necessarily changing the base way of how we measure success in the space of working or your content working the technology or doing what people with disabilities need. There's a major change coming up in 2 or 3 years, 3 or 4 years. I don't know. Everything seems to be pushed back a little bit here. In fact, WCAG 2.2 is a little bit late. They're off schedule right now for some of the things they're doing. But WCAG 3.0, it's nicknamed Silver. So only some of you probably in the United States my age will get this. So the medal, not the horse, the Long Ranger's horse. So the reason they call it Silver is you've got Accessibility Guidelines AG, grab your periodic table of the elements. and that's silver. So that's where that came apart. I mean, when you work on these things all day, you have to find something to spice it up. So a little spiced with the name. So big difference here. And I've got a whole series on this as well that you can check out. Many of these things I'm going to talk about have um, other webinars and other blogs that you can check for more depth and detail. But the things to remember towards silver is it's actually not backwards compatible. It's going to be a choice whether you stick with the 2.2 series or go to 3.0. In silver, we really switch to an outcome and method and how to. Also, it has different levels. So you'll have bronze, silver, and gold, which is proposed right now to be a combination of critical errors and the percentage of your tests that have passed. But this could change. I mean, things change drastically from the initial proposal to the final candidate that's released. But what this really does is it gets us away from this it's no longer the binary yes or no, it either does or doesn't. We're really looking at the user experience and how that experience is for the user to guide us to spend the right amount of time and effort we need to spend on accessibility, but not too much, because your primary business, unless you're me, is not accessibility. And so this is something that has to fit in with you. So I'm excited to get to silver. DQ has many, many people working with the groups that are creating these. And my partner in crime, you've probably heard of Glenda Sims, Goodwish Glenda Sims. She's involved in silver as well. So more to follow on that. But these are the things that guide the accessibility. So we've got the drivers. Somebody's saying we have to do it. We've got the guidelines saying here's how you do it. And so let's talk about doing it. Before we do that, though, I do want to talk about, and this is again a repeat. Like I said, a couple of years ago, I had a chance to interview a few companies about their complaint and their lawsuit costs, and really looked at the situation in the light of all the activity that occurred that had to happen to get the lawsuit to complete or to get it to settle. And I'm going to go through these very quickly. You can look at the numbers back on the slides, but the point I want to make is when you get a complaint, which we're talking about first, the key things about that is how is the complaint handled? How long did it take the person to get to somebody who could help? And was all of this done with empathy and speed? You know, many times you can get a complaint and avoid a lawsuit if you get them someone who understands accessibility, understands disability, can talk to them and help them. And then you can also give them an immediate accommodation. So if they could have got a 20% discount on the web, but they can't order on the web, give them a 20% discount on the phone, or give them a 30% discount and say, I'm sorry, it didn't work on the web. Whatever you do, you know, just to make sure the person's made whole immediately. This determines whether you have the unhappy customer, if they miss something, and then they become a motivated customer with a real issue and real damage, i.e. I paid more than a non-disabled person would have. And did I make them whole with a delightful experience, i.e. give them a 30% discount instead, apologize, go back and fix the issue that was blocking them, and then call them and say, hey, can you try it out again? I fixed it. You know, I'm really sorry we missed it, and we've got it done. So about handling, you know, your customers, there's a way to do this the right way and a wrong way. Many times we see customers complain that they feel ignored, or somebody might ask a person who is blind to do something that obviously a person who is blind couldn't do, which means that the call center rep didn't necessarily understand their disability etiquette. So important things there, but the other important thing is the cost. And in this table represents the things that people do. So you're receiving it, you're processing the issue, you've got to spool up a project to fix, all the things that happen down, and I'm sorry, I'm pointing at the screen here, but all the things in this chart that happen, the actions, the number of people that have to work on that action, the number of hours that they spend doing it, the total hours, and the extended cost, which I think I just used like maybe an $80 an hour cost average here, a banded cost average. So, but you can see these things add up. So, I mean, a complaint could very quickly cost you, and look at the reactive fixed cost, which is the third line in this chart, almost $10. We know that a proactive fixed cost. So if this issue actually occurred in design, so let's take a very simple example and say that in design, there's a submit button, and the submit button wasn't tagged as a button. It didn't have alternative text. It had a dialogue trap box before it, and whatever happened, it kept people from pushing the button. Had we addressed that in design and properly marked it up? So we did a review and they're like, oops, you forgot to say it should be a button. You forgot to make sure it has appropriate alt text. You forgot to make sure that your focus is there, etc. it would have cost maybe $100. I mean, probably less than an hour's worth of a banded average work for a developer engineer. So 100 times is the difference between that customer calling in and somebody fixing it as part of the software development lifecycle. So 100 complaints a year, suddenly you're at $1 million. Now, for many of you, $1 million is not a lot of money, but $1 million will do a lot of testing. It will purchase a lot of tools. It will give a lot of training and awareness to people who need to do this. So I would rather spend $1 million on proactive activity aiming for that $100.50 cost versus the $9,949.50 cost. So what do you do? Eliminate defects, making it production shift left. And when I say shift left, I mean catch the production in the phase in which it was injected. So if it was injected in the design phase, which we've seen with some studies that up to 70% of defects in this space originate in design, and I have a good design review, then I've just fixed it at the cheapest position possible. If I move to dev, it costs more to fix. If I move to QA, it costs a lot more to fix because now we're opening tickets, we're doing all kinds of interesting things to manage this. We're prioritizing, we're disrupting the train of functional requirements. If you're in Agile, it just becomes a very, very big issue. And then of course, if you get out to production, now you've got all kinds of things going on. So, and then make sure your response channels, your customer care folks, your disability support team, if you've got something like that, handle that person with expediency, empathy, efficiency, and a permanent fix. So there's things you can do here, certainly, to make this much better, and you're really just avoiding that person having that problem. So the lawsuit costs are similar, but much, much higher because we've got different things that go on. The lawsuit's going to require new and more expensive resources, additional ones. The lawsuit demands a response, which can become burdensome. I mean, it's not difficult to look at the call and say, oh, that's Bob calling about my submit button again. I'll skip that. Maybe he'll go away. When you get a lawsuit, you have to respond to it. And a lawsuit is just burdensome by its very nature, which probably should be. It's also going to involve senior levels of your company when you've been sued. Typically, your C-suite would like to know about that. They would like to know why. They would like to know what you're going to do. They would like to know how you're going to fix it. And they would like to know whether they're going to show up in the Wall Street Journal. And finally, what are you going to do to make sure this never happens again? So a lot of things, this adds to the aggregate risk for your company. So now you see I'm getting into talking about risk. I know I'm with 20 minutes in and I haven't talked about risk yet, but here we go. The aggregate risk of your company includes everything you do, also the exposure of things that don't meet requirements, especially legislative requirements that then could result in some type of fine or risk or loss, whether that goes to an individual party or Department of Justice fine or something like that. And then usually a lawsuit's also going to call for outside counsel representation. It's probably doubtful that you're going to have general counsel or general counsel staff that understand accessibility and IT to the degree to be able to represent this in court. So you're going to have to provide somebody with a retainer to represent you, especially in the jurisdiction you've been sued in as well. So this is another table that includes all those activities, but you can just see that the costs are much higher and the amount of hours that we're putting in are higher. You know, you've got to assign the lawyers and notify the business. We've got a retainer that we're putting in. We've got communications, this court order processing and documents. I don't know how familiar all of you are with that if you've been party to a lawsuit in a corporation, but basically what happens is they freeze your records management. You can't go, you could, if you want to go to jail, but you shouldn't go shred all the documents and delete all the emails related to deciding not to fix an accessibility issue, right? You've got to save those because those could be, as part of the discovery, they pertain to the situation that you've been sued for. So you have to get those documents to outside counsel. You've got status meetings, prep court status hearings, prep for negotiation, et cetera. The first time I gave this, I had about 3 lawyers, or I think 4 lawyers in the audience. All 4 walked up to me and said, wow, Greg, your numbers are way low. We charge way more than that. Yeah, obviously we charge more than that, but so this is very conservative. And so when I give you the total, remember that that's probably the least amount you're going to get away from. This particular one that I've got here was from a lawsuit that was very quickly settled for a very low amount, right? And so this total doesn't even include the settlement that was paid to the individual or the legal fees that were paid to the individual's lawyer. But once you get into that settlement piece and now you have to do your hold order release, which is letting all those records go, again, more administrative activity, we see that this litigation grand total can reach up to $250,000 or more. In fact, the average across the ones that I've been able to talk to, and not everybody will talk to me about this, certainly off the record and don't use my name, they will, is more around the level of about $350,000. So I've got a very simple lawsuit, but the people I had to involve, the things I had to do, suddenly I've spent $350,000. So once again, that 250, 350, $400,000, however much it costs, could be spent on other things like training your designers, training your developers, providing tools and automation and testing, et cetera. So just really money you're spending that's not moving you forward, likely, and it's disrupting your company because there's other things these people want to do. They're not just sitting around and turn around and say, "Ooh, look, I got 20 people sitting here waiting to respond to a lawsuit, and I'm glad we got one because they weren't busy." That's not the case. They were doing other things. So what can we do? Again, these things still apply, and I'm going to repeat these at the end too because it's part of the overall risk mitigation strategy. But eliminate those defects, making it production again. Ensure you have automated reports that are 100% clear. So use something like AxeCore and then fix the things that AxeCore shows you. There are, as I said, some people who are looking to benefit from the way that the laws are set up here in the United States. And when they do that, they're usually targeting an industry. So they may target movie theaters and hit 50 movie theaters, or they may target retail and hit 50 retail companies, or banks have always been a big target. I mean, we're talking financial here, banks, investing, those were the initial big targets and still are. So when they look at your website, if you have things like an accessibility statement, if they use a scanner off the shelf to scan, if they use the right scanner, some of the scanners out there are just terrible with false positive. But if they use a good scanner, they're going to scan your website. They're going to see that there's no automated issues. They're going to look and, oh, they've got an accessibility statement. Oh, they've got a special line to call in. Oh, it looks like they've been doing this 2 or 3 years with a material investment. They're much less likely to say, I'm going to hit that company than hit a company that has some issues on their website. You can't like do a control F and try to find accessibility from the homepage. There's nothing there. It's just the difference as they shop around for which companies they're going to go after, because unfortunately they tend to just go after companies with a little bit of information versus actually saying and trying to become a customer and running into an issue. It's usually just that. Now, a note about this too, I like to say this, I'm sure there's some lawyers out there in law firms that are taking advantage of this. I think personally, this is GW's personal thought, I think personally the individuals involved, it's a form of advocacy for them, right? So although it upsets me that some of this happens, I realize that in some cases, I think most of these people are motivated because they really want to make it better for everyone. But in these situations, it's not really making it better for everyone. There's money going where it's not going to help. It's raising awareness to some degree, but it's just the wrong way. I really dislike the negative motivation of it. So please don't fault the individual, the people with disabilities who want to use your things. And this goes back to your website too. If you haven't spent a penny on accessibility and you get sued, then, well, what do you do then? Really nothing, because you're not in compliance with what I'll say is established guidelines and beginning to be established case law. So all these things are assuming that you're working on accessibility and trying to make it better, but prevent that complaint from becoming a lawsuit. You've saved a little bit of money, but still in the end, you've got money going in the wrong place. So that's why everything is important, is because you've got the risk out there. You've got money that's going, that's not really helping digital equality. It's going to people, the wrong people, we'll put it that way. So that's why it's important. Another reason it's important is because of the current legal landscape. And I know you guys have seen these many times. Safar Shah is the source for this information. So I'm trying to remember her name. I'll think of it in a minute, but Christina Lani, she has a presentation. Again, here's another one where you can go into more detail on what I'm talking about here. But I'm just going to share with you what's been going on, and you can see very easily from the numbers and the graphs provided here that Safar Shah has collected and presented that since 2013, we've seen an incredible increase in the number of ADA Title III federal lawsuits filed each year. In 2013, which is the extreme left side of the graph, 2,722. In 2020, 10,982. Now, that was actually kind of a weird year because there was a 1% decrease, but we've got to remember this COVID thing, which is why I'm working at home in my home office and not with all my peers someplace else, or visiting with you. Hopefully QA Financial can have an in-person thing where we could talk before and after eventually. And I think Matthew said they're planning on it. But COVID really slowed things down a little bit, but I will say that we're on track this year to see another large increase. So the numbers are still emerging. It's difficult to collect this data, so I do appreciate Safe for Shaw doing that. So we've got it, but you can see that these increases are marked, and they're also significant, right? 16% increase. I think 2018 was the big banner year with a 33% increase. Actually, it bracketed 2016, 38%, and 2018, 33%. So they're on the rise. We probably won't see these tailing off until accessibility gets better, or until we see some more guidance from the Department of Justice, the Americans with Disabilities Act, or other legislation that really clarifies the rules and guidance for companies. That's the hardest thing here, is that the Americans with Disabilities Act, because of when it was written, doesn't really say anything about the digital storefront, which we call a place of public accommodation. So there are arguments between district courts across the United States on whether a digital storefront is a place of public accommodation. So we're really just arguing about where this applies or not versus, if it applied, how would it help? And I think the help is the better part of it to really think about in this case. So going down through that, we've had different administrations. The Obama administration, there was actually at one point a proposal for rules. We thought we were going to get something. It didn't happen. The Trump administration came in and canceled really literally all business rules. Not a bad thing. Do I think we're overregulated in the United States? Perhaps. Is this a place where regulation, some clarified regulation, would actually help business? Absolutely it is. So now that we've got the Biden administration in, we are seeing them make statements and make moves that are encouraging, and hopefully we'll get something better than just having to search through case law and search through these different lawsuits and the different district court and DOJ opinions to come up with exactly what we need to do. A very clarified situation would be good for all of us. So this is, again, the federal court one. This is the in federal court 2017 to 2020. Just another, showing you what's going on there across those lawsuit numbers. There's also lawsuits that occur tied together with federal and state lawsuits. We've got UNRRA in California that's generated quite a few, but again, just numbers for you to see. In 2020, a 12% increase from 2019 up to 2,523. And then we're going to look at the states very quickly. And again, I talked about California and New York, and the fact that in California and New York, there's some additional legislation that people take advantage of. But you can see, really, these lawsuits are spread across most states. They're also spread across most industries at this point. So there's not really any place that we haven't seen affected by what's going on. Now I want to talk about some key decisions. So if we look at all the different lawsuits that have occurred, there's some key decisions that have come out that really guide us into thinking as a company, what are the things we can do to help our people with disabilities that would be considered acceptable underneath the law or acceptable underneath the current assumptions of the litigation and DOJ comments, as well as comments that come out from the circuit courts. So in 2019, we had a lawsuit. And again, if you want these, go to Christina Lonnie's. She's got, I think, actually links to them where you can read them. But I didn't want to go in that type of detail. But telephone service as an alternative to the web was not granted. So some people say, okay, you can't get it from the web, you can use the telephone. Or we've got some others. So separate but equal, or forcing a person out of a channel. So think of a channel as digital, a call center, walking in, or maybe mailing something in. The 4 different channels typically we see for business is increasingly being looked at as not an okay alternative, especially during COVID. If you think about a very good example, and I'm going to talk about Winn-Dixie here in a second, that you look at someone who was wanting to go into a pharmacy to get some medicine. If they couldn't set that up prior to going to the pharmacy, they had to spend more time in the pharmacy, which means that a person with disability unable to use the web was exposed to a viral environment longer than a person who's not. You put it in terms like that, it just says, well, that's not fair whatsoever, not at all. So it's easy common sense stuff, but it's things we still argue about. There was a bench trial verdict for the plaintiff in 2017. I'll mention that a bit more here in a minute. California in 2018, we had a summary judgment against the defendant under California's UNRRA Act. UNRRA is an interesting one that you'll see tied in more and more. I think I've seen 7 or 8 of those where I've actually talked to people about them yet this year. We had Scandinavian Airlines with the ACAA, again, separate but equal, prohibited. Separate but equal doesn't mean first class and third class or something like that. It means you need to give people access in the same channel. And then in the 11th Circuit in 2018, we had barriers on the website that prevented the plaintiff from accessing services in the physical store. And that's that example that I just gave you of someone who wanted to perhaps pre-purchase something on the website. Another great example would be grocery delivery. Some grocery delivery services simply available for order only on the website. You pull up, you open the trunk, people put the groceries in, can't do it. So now I have to walk into the store and again, exposed to that viral environment and whatever the additional exposure is for the person, which again is just not equal. It is not digital equality. Now here's some ones that I want to really focus on. I've bolded these, which when you bold everything on a page, it just looks like I've used a different font, but they're all 3 important. So in the Southern District in 2019, these situations where because of proactive activity at the company, meaning that they had focused on accessibility, they were doing things, they were fixing things, they had a program, they had other pieces and parts in place, and although they may not be 100% accessible, they were obviously making a material effort. So one of those in New York in 2019 was dismissed with a declaration stating that all the barriers have been fixed, no additional barriers exist, and they had a forward commitment to accessibility. So an actual dismissal. Another one in the Eastern District, New York of 2020, it was dismissed because the plaintiffs didn't clearly explain how they were blocked from that activity on the website. And then they also had an expert consultant declaration from the defendant, which would be somebody, could be one. I mean, there's a few of us who have done this before at DQ and other companies, but this is where somebody said, I'm not just going to pay, an extortion fee. I want to know what's actually wrong so I can fix it. And then let me get an expert to look and see if they agree. And this person couldn't explain what was wrong. So again, dismissed. And then another one that's recently come up too is the lawsuit was dismissed because the plaintiff couldn't ever even become a member of the institution they were suing, which is a credit union in that case. So some of the courts are getting a little bit better about not just immediately rolling over and saying, yes, you're a terrible company, you have failed the people with disabilities community. They're actually looking at some of the data. These things are complex though, and it's hard to expect a judge and a jury to understand some of the nuances of accessibility. But if you're taking action, you have a better chance now than you had before of defeating some of these lawsuits. And in turn, spending that money, taking that money and spending it on accessibility, and then also getting your name out there as someone who's not just going to pay out an extortion fee, every time they receive a demand letter or something of that type. So I want to talk about Winn-Dixie real quick, because this is a situation where a lot of people jump to immediate conclusion that, oh, suddenly we don't apply anymore. This is such a setback, and not actually that much of a setback. I think it's just a temporary blip. But back in April, a single U.S. Court of Appeals, this is the 11th Circuit, decided in a 2-to-1 split decision that Winn-Dixie's website didn't have to be accessible for people who are blind. Yeah, so don't agree with that, obviously, and we know that that's not something that we want to do. So I just want to show you how that happened and some of the things around it. So there was an immediate request for rehearing. These requests have gone in to consider, and this is the makeup of the judge panel. So there's actually 12 judges here. This particular one was heard by 3 of the judges, so they're randomly selected, I believe, out of that. 2 of them said that the Winn-Dixie website doesn't sell anything online, so it doesn't need to be accessible. One of them wrote a very long dissenting opinion that said, yes, it does need to be accessible. In the meantime, Winn-Dixie started selling things online, but we can't introduce that because it's new information on the lawsuit. But what we're going to see is we've had at least one of the other 12, or the remaining, I guess, 9 people on the panel said we would like to have all 12 judges rehear this. So we think that this is going to be probably reversed. I mean, this particular group has made decisions that are absolutely opposite of this. Not really sure exactly how this came about, but more things to come here. This does not mean suddenly that websites aren't subject to accessibility needs. Even if we came back and said they're not, it's still not the right thing to do. It's still not the right way to reach humongous market segments, close to $500 billion in disposable income of people of working age just here in the United States. And there's even bigger numbers, of course, around the world. So again, only 3 judges, 2 of them said that because they're not buying things, it's not covered. One of them wrote a 34-page dissent. Again, you can go out and find that. It's beautiful to read, because I think with that judge, it would be interesting if they actually even wrote, went over and wrote some rules and guidelines for us, because I really like their interpretation. And then why also is it a little weird? So it's the 11th Circuit only hears for these 3 states. And again, I'm pointing at my screen. I apologize. Used to be in a room full of people, but Alabama, Georgia, and Florida. So that's decisions only there. And you can see on this graphic the rest of the circuit courts as well represented. So the court decision could be changed in a number of ways. Like I said, an anonymous judge has asked for it to be reheard. The plaintiff has filed for a petition for rehearing by the entire bench. And then 10 organizations filed a brief together requesting the Winn-Dixie case be reheard by all 12 judges. So that one's probably going to go back the other way. And so what happens if it goes back the other way? We'll probably get a ruling in the opposite direction. Okay. So we're coming down to the end of it. I definitely want to leave some time for questions here, but I want to talk about strategies, the things that we can do. So what can we do? This is a repeat. You'll see, eliminate those defects, ensure your automated reports are 100% clear, you don't have false positives, enable your response channels for customer complaints to handle contacts with expediency, empathy, efficiency, permanent fix. But what else can we do? Part 2. So material efforts and investment in accessibility can make a difference. Invest your lawsuit handling dollars in education, training, knowledge-based resources, tools, testing, remediation, have a formal plan for ongoing accessibility, have dedicated and certified accessibility resources, mature and present your progress. Just a number of different things that you can do to be able to
Well, I apologize. I think Greg has dropped out of the presentation. We're going to have to see if we can get him to connect again. Bear with us for a moment, please. He's coming back.
I am so sorry. Power blip. Am I back, Matthew?
Yeah, you're back, Greg. No problem at all. You were just away for 30 seconds there, but you're back with us. You dropped out of your presentation mode, so if you want to click back into that.
Okay. Are we back?
Pick up where we left off.
Okay. And this is where you lost me?
You're not in presentation mode.
Oh, you're not presenting. Okay. I'm so sorry.
You were just getting into the section where you'd said you're going to leave some time for questions, but we're going to get into the checklist of things you can do.
There you go. This is what everybody's been waiting for, and then the power goes out here. That's why we're having storms today in Illinois. Okay. All right. I'm back with you. Does all look good, Matthew?
Yep, that looks great. That's good.
All right. Apologies. Let me start this one over. So uh, we talked about what we could do prior when I was talking about the expenses related to the complaints and expenses related to the lawsuits. So these things still certainly apply in what you're doing. But the real benefit comes in having that material investment in accessibility and making a difference in the actual accessibility of your website. Like I said before, if your website is completely inaccessible and you get a lawsuit or a complaint, then you just have to fix it, right? But what that means is you're probably going to fix it under duress with disruption at a higher cost and in an inconvenient time frame. So let's get rid of all that and say we realize that at some point in the future we're going to get complaints, we're going to get a lawsuit. So let's set aside that $2, $3, $4, $500,000. Again, we're not talking about millions of dollars to fix this, and let's invest in things that are going to help you. So what are the things you can invest in? Primarily, the first one, education, training, knowledge-based resources for your people who are both conceiving and designing and building in the software development lifecycle. Tools, testing, and remediation, and I should say tools about 50 times here. There are tools out there in the industry, and DQ provides, of course, I personally feel they're the best tools that can get you above 80% of the defects that we find present in most websites with very little effort. In fact, you can get above 50% simply by pressing a button and testing automatically. And then you get up to the rest of the 80%. There's a few questions that we need to ask a human that we don't quite have artificial intelligence for yet, where we can determine if there's an issue. So, and then remediation, obviously prioritizing and fixing those things you find. Also, have a formal plan for ongoing accessibility improvement. A program or a center of excellence is best. A document and a plan agreed to by the participants and your senior leaders is good enough just to get started, but have an actual plan that says, here's what we're going to do, here's what we're going to invest, here's how many years we think it might take or how many months we might take, and we're going to focus on executing that so that when the lawsuit comes, or the complaint comes, you've got something to say, yes, I'm absolutely working on this and thank you for your input. Let's figure out how that fits. Have dedicated and certified accessibility resources. This could come from a company like DQ, but long-term, you're probably going to want to build some of these people inside of your company. Just like you have security experts on staff, likely, you'll want to have some experts in accessibility. Now, do you have to have 100 experts in accessibility? Certainly not. But you're going to want to have somebody who can watch assistive tech and all the other things that go on around the technology, as well as evolution of WCAG and evolution of the legislation, so that they can guide you forward. And then measurement, document, and present your progress. So measure, measure, measure. Anywhere you can take a measurement to show the difference, the return on investment that comes from the accessibility, the amount of cost that you're injecting to be able to make your content accessible. Keep all this information handy and close so that you can talk to people about it. And then finally, let the public know you're invested in inclusion. So as I said earlier, if I go to a website and I run AxeCore and I don't get any issues that pop up, or I get minimal issues, maybe I get a few color contrast issues that aren't really that bad, and I find a link on the footer that says accessibility, and that accessibility takes me to a portal where I can read about what you've been doing. I can get in touch very quickly with someone who understands me, understands my disability and my needs, and I can get help for the things I want to do. Very unlikely for me to, file a formal complaint or move to litigation or something of that type. So it's important to let people know, what's going on and give them an avenue to come in and help you make your website accessible too, because most people, they want to do that. They want to help and say, this could be a little bit better if you could do it this way. So if I see that portal, there's no issues on the page, it's obvious that you're focusing on it. Then if I'm a drive-by lawyer, I'm probably going to just drive on by you, right, instead of stopping. Now, is that 100% guarantee that they won't stop? Some of those drive-by lawyers don't know anything about accessibility, so they still may stop, But if they stop and you tell the judge, wow, I've been working on this 2 years, I've got education, training, tools, testing, here's my formal plan, I've got certified resources, here's my progress, and then they never did even explain to me what's wrong, how do I fix it? The judge is probably going to take a pretty narrow look at the lawsuit that's been filed, or at least they should if they're a good judge. So that's the list of things to do. Behind each of these bullets, there is an immense amount of additional things there, and it would take probably another hour to talk about that. At some point, perhaps, I'll come back to QA Financial and we'll focus on some of these, or we'll focus on some of the DQ work that we do. But yeah, that's Matthew, what I had to share. So let's see, do we have any questions or
Yeah,
comments
we
or
certainly
people want to
do.
talk?
First of all, yeah, Greg, thank you very much.
Hmm.
Really interesting update. We've got several questions actually, and we've got 9-10 minutes before our hour is up.
Good.
So I've conflated a couple of them because a couple of people have asked about what about the particular legal situation for financial institutions and the particular testing requirements for financial institutions. You talked about functionality earlier, and you gave us well the very important current example of Winn-Dixie, which is of course a supermarket chain. But what about financial information and the particular challenge of testing for accessibility in terms of the way financial firms communicate quite complex financial information?
Yeah. So I'm thinking we're thinking more investing house than bank here, probably.
Yeah, sure. But I mean, for example, I guess it could equally be a mortgage, or yeah,
Hmm.
it could be a complex KYC process.
Yep. So from a financial perspective, you've got two different things at play here. Number one, you've got sensitivity to the information, right? So if somebody accidentally finds out what kind of potatoes I'm buying, I'm probably not that upset about that. If somebody accidentally finds out my net worth, I may be more sensitive to that. There's an outstanding accessibility exercise that one of my peers did one time, and we were sitting in a room with people, and they said, "Everybody, please write down your username, your password, um, and your bank URL, and then pass that to the left." And what they were pointing out was that for them, because the login to that information wasn't accessible, that's what they had to do. They had to tell somebody their very personal information. And that person had to read back their very personal information, how much money's in your checking account, how much did you spend on, what they bought or not. But, it's not being able to do it independently. Similar to voting, until the electronic vote, people couldn't vote privately if they couldn't, if they had disabilities. But within the financial things that are presented, there are some very complex things. And we think about a screen that updates from investing real time, or you think about presenting mortgage tables and things of the like, or different pieces that may seem difficult to present in an accessible format. But what I'm going to tell you is that in 10 years, I've only really seen maybe one thing that we continue to struggle with a little bit that we couldn't create in an accessible way. There are usually always alternatives to communicate that information and data across, and some of them are fairly common. And the one that we stick at is there's a couple of investment houses that have these real time screens up where you're watching everything, and that's just, think about a person who is blind and they're trying to get that much information off the screen at any given time in an aggregate. Now, I'm going to go back and say that if I look at some of those screens, I can see just fine with my glasses on, and I still can only concentrate on one or two things at a time. So it's not like you can understand all those at once. But for those financial pieces and things that seem to be complex um, and may seem like a challenge, I can tell you that we've been able to find solutions for nearly everything, unless there's a specific one that somebody wants me to talk to, if they've got an example. But
Okay.
accessibility does not mean that your designers have to give up their ideas on experience, right?
Okay.
You can take
Okay.
an experience and still make it accessible. Don't make the interface overly simple because you don't have to. right? Accessibility can handle it. The technology is available. The assistive technology works today in ways that it didn't 10 years ago, and it's just very, very good.
Okay. And by the way, Greg, if you don't mind dropping out of presentation mode so we can
Oh,
see
okay.
you more clearly, just for the final couple of questions. Um,
Okay.
that's great. Thank you for that answer. But the other related question was, I mean, is the legal position of financial firms with regard to accessibility actually different from any other company operating on the web?
Not to, so I'm going to talk about the United States, and I'm going to say once again, I'm not a lawyer. This is not legal advice, right? Not that I have seen. So the major question 5 years ago is my content, is it a place of public accommodation as defined by the ADA or not, right? And in many cases, financial institutions took the position that it's not clearly a place of public accommodation as defined by the language in the ADA. And remember how long ago it was written. And at that point in time, you also had, let's remember how many bank branches there were 10 years ago versus how many there are now. I can't remember the last time I went into a bank branch, just not, you don't go to the physical office anymore. So the thinking has changed now that in general, people say, yes, I understand that this is a place of public accommodation. Even if the ADA comes back and says it's not, for me to do proper business with my customers in the way that they want to do it, with the privacy and with the ability to be independent, we're embracing this. And I'm seeing that across all of the financial industry. This year, interestingly enough, I'm seeing it across pharmaceuticals. They're a new, I mean, just, I couldn't explain to you sometimes where the pivot point and the change is, but I don't know any financial institution right now that I've talked to, and this is dozens, if not hundreds, that says, I just don't think the law applies to me. What
Okay.
they're doing now is they're saying, even if the law doesn't apply to me, this is good business. I'm going to try to figure out how to do it.
Okay. Another question about Europe and there's a European EU directive on accessibility.
Mhm.
I guess the actual letter of the law is similar to that in the United States. Perhaps you could comment on that. And also, are we moving towards a single set of global standards for accessibility?
Yeah, so I'll take the first part of it first. Is it similar? So yes, it is similar. What you see is you see people taking WCAG just at base value. So we'll use Ontario and Canada as an example. They just say WCAG 2.0 or AA by this date, right? But we also see some that are taking derivatives of WCAG. So they're still basing it on WCAG, but maybe not everything. And I'll give you an example. And this goes back to Ontario and some places in Europe where they've exempted things like descriptive audio. Because that's very, so descriptive audio is I'm watching a movie, all the actions in the background, there's no dialogue. So all I hear is people getting punched or thrown or things falling. I have no idea. So the idea is that somebody describes what's happening in a second audio track and doing it. So there are some places where they look at that and say, that is just so expensive to ask somebody to do because you need to have an actual writer. I mean, you really need a screenwriter to do it, that they're giving additional time to do it. And that's the other change that I see too is most of the legislation now realizes that we have to have a phase-in period where we put certain scope under, we reach a certain level, we increase the levels. But the whole point here is we want the people with disabilities community served, but we don't want business to be overly burdened. So working it in. Towards a worldwide standard, I think when we get to silver, right, which gets away from this binary yes or no answer. Now you can choose, do I want to be bronze? Do I want to be silver? Do I want to be gold? Do I want to go for the gold standard? What's my combination of critical errors versus test pass and things like that? I think this is when we're going to get to the world standard. Now, who's going to write the standard, right? Because WCAG, it's just a guideline. It's not a standard. So right now it's incumbent upon most companies to take WCAG and create an internal standard to which they develop. For litigation, I don't want them to be too specific, right? I mean, if they get very, very specific, I think that's going, I'm not litigating, I mean legislation. They get very, very specific, that's going to cause some problems, right? So we still want them to lean on some outside body and talk a little bit more in generalities about, yes, it's required. Here's a guideline that provides minimums. you choose where you go based on the experience you want to provide. But 2 or 3 years out, so I mean, for silver, which is with CAG 3.0, that could be 2, 3, 4 years out. But that, I think, is where we'll start to see this come together. That's also where I think we'll see almost all countries have some type of support for people with disabilities in their digital space.
Okay, Greg, we have to leave it there because time's up. We do
Okay.
want to give our audience the opportunity to visit DQ in the stand in the exhibition area. To your right of your screen, click there, and you can meet the folks from DQ who are there to chat to, and also to find out more about the technical content you can download from that stand. But Greg, thank you very much for that session. Really informative.
Thank you, Matthew.
And I hope we'll be speaking again soon.
Yeah, absolutely. Thanks, everybody. And everybody have a fine morning, afternoon, evening, whichever it happens to be.
Thanks, Greg.
All right. Good day.